Hi guys, this is Group 14 and we are back at it again. We'll be discussing the determination of trust, which entails ways by which a trust can be terminated. Stay tuned.
A trust is a relationship that arises where a person, called the settlor or a testator, transfers property to another party known as the trustee for the benefit of a third party known as the beneficiary.
Ways in which a trust can be terminated. Number one, revocation by the settlor. Generally, an agreement of trust cannot be terminated unless the settlor expresses his reserved power to terminate the trust in the agreement. So when a trust is revocable, the settlor can choose to revoke or terminate the trust at any time he chooses, as long as the purpose for the trust agreement has not yet been fulfilled.
In the rule of Saunders versus Vautier, the testator gave his property to a trustee to help him invest in the shares, and the profit should be given to his child at the age of 25. But at the age of 21, the child demanded for the property.
The court held in this case that a beneficiary can demand for the distribution of the trust assets inasmuch this beneficiary is full of age, is an adult, and has a mental capacity to make decisions, and also absolutely entitled to the property.
Another way a trust can be determined is by disclaimer. Disclaimer means when a trustee gives notice that he is no longer interested in carrying out the trust, and it is preferable for him to do this by executing a deed. And it could also be inferred from the conduct of the trustee. For instance, where a trustee has decided not to act for a period of 10 years, so it would be inferred that he is not acting and that he has disclaimed. And we could also see the case of Nylander versus Thomas.
Retirement or discharge. A trustee can retire or give notice of discharge according to section 26 of Trust Law of the State.
A trust agreement can also be terminated by removal of the court or overt by the court. This happens when the court orders that agreement be terminated when it realizes that the trustee has not been acting in compliance with the intendment of the act, or he has been mismanaging the trust property.
According to Section 839 of the Companies and Allied Matters Act, the court can make order for the termination of a trust if it discovers it is being mismanaged by the trustee and it is at the best benefit of the beneficiary. The court may further appoint an interim manager and make provision for the administration of the trust, which may be later terminated.
In Adeshe versus Williams, the beneficiaries of Adeshe's estate accused the executors and trustees of mismanaging the estate and sought their removal. The trustees denied the allegations and argued that the estate was being properly managed. The court held that a trustee can be removed only where there is misconduct and where their continued presence is harmful to the proper administration of the trust. And since there was no evidence of mismanagement, the court refused to remove the trustee and dismissed this case.
So, I hope a lot has been added to your wealth of knowledge on the determination of trust. Thank you, like, comment, and share.